We are on the record in 22 CR 1266, trailer 1 and 2, that is Commonwealth of Kentucky versus Mekhi Cable, and Commonwealth of Kentucky versus Demaurion Moore. Council, can I get appearances for the record?
I'd like to brush on behalf of Mr. Moore. He's seated next to me.
Good afternoon, Your Honor. Lana Fazio from Mekhi Cable, seated to my left.
All right, before we get started, we'll talk about a preliminary matter. If I ever get a phone call while I'm on lunch that you two are fighting and acting a fool, you will not be happy. I don't know how you all ended up in the same place or the same area, but that is 100,000% disrespectful, and it will not be tolerated. I'm not your mama. Don't play with me. You all are in here with charges of murder, and you acting a damn fool fighting in the back. You know what a fight is? That's an assault charge. You want another assault charge added on to this? Do you? To say I'm disappointed is beyond ridiculous. It makes no sense. You have on an orange jumpsuit. You have handcuffs on, and you in the back acting like damn animals. What's the problem? You don't have to like each other. You don't have to get along. You can have whatever defense that you want, and you can have whatever defense that you want. Y'all in court. Y'all are not here to be friends. I don't care what your defense is. You can say he did it. You can say they did it. You can say I did it. I don't care. But what you won't do is be violent. What you won't do is impact somebody's safety downstairs. What you won't do is have me talk to you like this ever again. Do I make myself clear? If I heard that you as much as made a threat, I will hold you in criminal contempt. And I am sick and tired of every time I get on this bench, I have to say something to somebody. Act like you got some damn sense. Do I make myself clear?
Say, yes, ma'am, Demaurion.
He said yes, ma'am.
I'm sorry.
Don't be sorry.
You say it loud and clear to where she can hear you.
It don't make no sense. Do I need to just have y'all up here? Because I can separate you all day long. You will not hurt him. You will not hurt him. Don't say nothing. Don't defend yourself. Don't say nothing. I don't care how it got started. I don't care if you were defending yourself. I don't care if y'all threw a blow. I don't care. But when I get a call to ask me if I even want to call your case, it's as simple. Look at all these people in here. The media's here. It's 1,000 people in here about your futures. About lives that have been lost. And because y'all want to act like babies, it prolongs stuff. Do you think that I'm going to give somebody HIP, I'm going to give somebody probation, or I'm even going to think about an alternative sentencing plan or anything like that when it comes to the Department of Justice, juvenile justice? I make those recommendations. I talk to those people. I work with them. I get to decide what your future is. Me. And if y'all back there fighting, you think I'm going to trust you to do anything that I ask you to do? Do you think if you ask me for probation because it's allowed under the code for you to request it, that I'm going to be inclined to do so, and you back there fighting, allegedly? Shake your head no. Okay. I'm not playing. I'm not. I'm nice until I'm not. I'm not playing with y'all. You walk the straight and narrow. You do what you're supposed to do. You an 18-year-old child. There are monsters in prison that would hurt you without thinking twice about it. You are not hard. Ain't nobody scared of you but you. Don't let them tell me I did nothing else. All right, we're here for oral arguments as well as pre-trial conference. I note that there are 3 different issues on this case. There's the issue that occurred, I believe it was October at the bus stop. There's one that occurred on Thanksgiving, and then there is a precursor to all of this that involves another juvenile.
That's right.
We've asked for different things, for things to be separated, etc. I'm upset. So mine ain't even working right. But I'm not going to waste everybody's time. So we're going to get through this today. Okay? All right. Ms. Conroy, do you want to give the court a brief update?
Yes, so this is our first of monthly regularly scheduled hearings leading up to the trial date next year. You are correct that a motion to sever both the defendants and the counts was filed by both Mr. Cable and Mr. Moore. The Commonwealth is objecting to both the severance of the defendants from each other and the counts from each other.
All right.
We then responded in writing. The Commonwealth filed a brief that was some length. We cited not only arguments but law to the court. And then I believe Mr. Cable's counsel filed a reply. Mr. Moore's counsel filed a brief reply standing on his previous arguments. What I think the parties think we're here to do is just argue the court briefly. Obviously, from my point of view, most of what I have to say and what I think the court should base its ruling on is in the facts of my brief and the arguments. But I know just because this is so important to all parties that people might want to make some oral arguments to the court, then I think the anticipation was that the court would take this under submission. Obviously, you're free to rule from the bench, but this is also very serious for you.
Right.
So I think we were all assuming that you would take it under submission, and hopefully we would have a ruling by that next date, which is August 15th, so that we would know what the look of the case would be as we're marching forward, what we would be trying when we try this case. As to the pretrial portion, and sort of just update there, this is one of those where you've heard us talk. It has a lot of discovery that everybody is getting through, but it is, I believe, to be complete, so it's not like we're waiting on anything.
Okay.
It's just a matter of going through all of the motions that are a direct result of having serious charges in a serious case like this so that we can be prepared to try the case next year. And then I think I also received an additional motion for bail credit filed by counsel for Mr. Cable. He'd filed a pro se motion, and I think we talked about last time how the court wanted that filed through counsel, and I requested that same thing, that he had appointed counsel and it should come from her. I did receive it. I'm not prepared to address it today. It's not going to be a complex argument. We're going to object, but I would like to be able to look it over and cite some law to the court.
No, I'm not going to rule on any kind of bail credit bond or any issue after,
No, and I
we'll bring that back.
understand what you're coming from on that. And I have had defendants in the past, and I know the court has sort of cited this as an option, that if you were to give a criminal contempt, all that does is take away their credit. So I know I've had other judges in the past give 6 months, and what that means is that they just did 6 months of the contempt and not towards anything here.
Right.
I know that you're contemplating that, and I think you made yourself clear on that. So I am prepared to respond to defense counsel's oral arguments as to their motions to sever both the defendants and the counts.
Okay.
In my response, I think I break down, not that they didn't as well, but on page 2, there's that indictment section where I kind of lay out for the court what the charges, each one of the charges, so counts 1 to 13 is the bus stop, and sort of lay out just a real quick what each of those charges mean, and then 14 to 16, and then that 17 and 18, just to make it a little bit easier, because it is quite voluminous in the indictment itself. And I believe Mr. Cable's counsel was going to go first, is what she indicated to me.
Okay, all right. I'm going to wait on addressing any bail credit right now. You don't want to make a decision today, okay? And out of fairness, I'm not ever going to make a decision when I'm disappointed, okay? Everybody makes mistakes. So let me breathe and sleep on it, okay? It goes for you too. If I was doing, I would do the same thing. Okay. All right, Mr. Raccio.
Yes. I believe, well, I can go first, it doesn't matter.
I mean, it doesn't. Whoever wants to go. Who wants to go first?
I can go first.
Okay. Ms. Fazio.
Your Honor, our motions to sever are, it's a lot. It's, you know, we're asking to have separate trials for the separate defendants. We're also asking to have separate trials for the counts. And, well, really for the 3 different incidences. And to be candid, I realize that, you know, what we're asking is for you to have 6 trials. And we're essentially asking for everything to start, but I think that in getting the written response from the Commonwealth and my being able to reply to their response, I think that there are just some very, very key factors that we're asking the court to consider and follow the law on, and not necessarily that at all that there need to be 6 trials. So even though that's our motion, my real focus for the oral argument is essentially really going to be on the ones that I think are not only not connected, but also would be the most prejudicial. So the co-defendant part of it, where we're asking to sever, our main concern for Mekhi is that there is a shooting at a White Castle. He is not charged with anything to do with that incident. The Commonwealth, I believe their words were inextricably intertwined in regards to the motive being that there was the same, they believe that there was the same targeted person from the White Castle incident to the bus stop incident. And as understandable as that is for Mr. Moore, with Mekhi Cable not being charged and having not claimed to have anything to do and no charges of the White Castle incident, it would be beyond prejudicial to have a prior shooting be admitted and the trial of the White Castle shooting, have the jury hear all of that incident in the middle of Mekhi Cable's trial in regards to the bus stop. It is exactly what the law is created for, is to not ever have a jury be faced with thinking, well, this incident happened, so it's very likely that this incident happened, and they're both shootings. So for Mekhi's protection, that should be separated out from him. In regards to the Thanksgiving Day incident, not only is he not similarly situated in the sense that he was also a victim from he was shot in the chest on Thanksgiving Day. There is no threat. There is nothing that could even arguably, that I'm aware of sitting here today, that the Thanksgiving Day incident has to do with either of the prior 2 incidences, other than the fact that they were both arrested. But the kind of test in regards to whether things should be severed is, would evidence in one trial also be able to be exposed and be used in another trial? And these are all months apart. They're not all, definitely all 3 of them don't even actually still include the 2 same people. One of them is completely separated out from Mekhi. then we don't have anything other than every shooting across the country is done almost with a gun. 9mm bullets, I think, was used as, something that might be a connection, but that we don't have any kind of traceable ballistics between any of the cases. 9mm are pretty common. Guns are common, and shootings, unfortunately, are also common. So there isn't any thread or motive that strings these three incidences together. And so for a jury to be exposed to all of them would be so overwhelmingly prejudicial that I don't see any probative value that could possibly save it. And I would reserve, Your Honor, that if I could have a brief reply after the Commonwealth's
that's fine.
Arguments.
I've allotted, I think, an hour or so for this, so that's fine. All right. Ms. Conroy, do you want to respond now, or do you want to wait and just
I'll wait.
respond once? Okay, all right. Is that it?
Yes, if
Oh.
Thank you, Judge. On behalf of Mr. Moore, I agree, it's probably a more difficult call to determine whether the defendants should be severed as to each incident. So what we're all calling the White Castle shooting, the bus stop shooting, the Thanksgiving shooting, which would create 6 trials. I candidly also would admit that that is a harder decision to make than whether the defendant should remain joined, but these 3 separate instances should be tried separately. To me, that's a much clearer question, because as the Commonwealth correctly cites, the standard is whether evidence at one trial would be admissible in evidence at the other trial. Now, they've laid out in their response why they believe they should be joined, not only as to each incident, but each count should also be joined, and that is at the White Castle, the alleged motive was the killing of Jihad Powell, Mr. Cable's brother, sometime previous. As to the bus stop shooting, they further go on and talk about the evidence, the alleged evidence that they have about Mr. Moore, obtaining a phone from a Mason case, using that to send messages regarding the bus stop shooting, where Rajon Baskin was also alleged to have been located. And then they jump into the evidence, in addition to the evidence from the Fanta bottle and so on, the DNA evidence, the text communications, so on. All of that pertains specifically to that bus stop shooting. All of that evidence, the DNA evidence, the text messages, the phone that Mr. Moore allegedly used, the motive going back to the previous White Castle shooting. They get to the evidence pertaining to the Thanksgiving Day shooting. None of that evidence is mentioned here in this shooting. The evidence there is completely different. If we look at these, let's start from the standpoint that they are already severed, and then ask, what evidence from this White Castle shooting or this bus stop shooting, let's assume they're separate, they haven't been joined yet, what evidence from these 2 incidents will come in at the Thanksgiving Day shooting? None of it would. I don't see how it would. It wouldn't come in under 404B, I don't think, other than to show propensity. These 2 guys acted together on this one occasion, therefore they acted together on this occasion. They're trying to use each of the 2 homicides to prove the other one. They want to use the bus stop shooting to prove the Thanksgiving Day shooting. They want to use the Thanksgiving Day shooting to prove the bus stop shooting. none of the evidence is intertwinable or interchangeable or would come in if these trials were not already joined. If we start with them being separate and then ask, okay, what from the bus stop shooting comes in at Thanksgiving? What from the White Castle shooting comes in at the Thanksgiving Day trial? None of it. I don't see how it does, even though they've correctly cited the standard, and that is the standard, but that's why it wouldn't come in. It wouldn't be admissible. I think that's a much easier call than the, asking for 6 different trials and severing them as to each individual event. If the court wants to keep them joined, the incidents should still be severed. The counts should still be severed. All of the counts pertaining to the White Castle and the bus stop shooting would need to be separate and have separate trial from Thanksgiving Day shooting. If the court does not want to sever the defendants, then the counts absolutely, I believe, should be severed, because I fail to see how any evidence, this evidence carries over, other than the attempt to prove one murder, alleged murder, one homicide, by proving another one. In other words, we'll use the bus stop to prove Thanksgiving, we'll use Thanksgiving to prove the bus stop. It's highly prejudicial. It's, again, I don't see, even under 404B, what would come in other than what would be characterized as propensity evidence. The motive, the alleged motive for both the White Castle and the bus stop has nothing to do with Cortez Duncan and the Thanksgiving incident, and vice versa. Cortez Duncan has nothing to do with the bus stop, Rajon Baskin, Jihad Powell, the White Castle. That evidence would not be admissible in separate trials if they were not already joined. And that's, if we start by analyzing it from, they are separate. Now let's see what comes in each trial. I think it's a much easier call for the court.
So let me ask you this is just my question. So, how do you say his name? Jihad. Okay, so Jihad dies. That's your brother. That's your brother. Okay. Then a few months later, there's an incident at the White Castle.
Right.
Yes.
There is allegedly, he's fine. There's allegedly some text messages going back and forth between Mr. Moore and Mr. Cable.
That's more for the bus stop.
That's the bus stop. Okay, right. So, okay. I'm trying to get the timeline down.
Mm-hmm.
So, but apparently, back in September, there were some text messages that relates to the bus stop.
Yes.
I need a car. I need this. Doing X, Y, Z. So that links. I'm just trying to follow along. Those two.
Right.
Friendship, currents, bus stop, killing. Okay? So that's one thing. So the one thread that we have is Mr. Moore throughout all of this. So now we have that. So that links the two of them. So then on the situation at the school, although you say there's no evidence, he's there. So that puts both of them back together. He ends up being shot.
You're talking
The Thanksgiving.
Thanksgiving. 3 incidents. Okay.
Yeah.
So then you have the Thanksgiving shooting. The two of them are back together.
Right.
Something's going on. Somebody pops up killed once again with the two of them together, and he gets shot.
Cable does, yes.
Right. Then there's a third incident that has absolutely nothing to do with him, but has to do with Mr. Moore.
That one came before.
That's the first.
That's the
So
first one.
the POW, the White Castle, the bus stop, the Thanksgiving.
I'll write that down.
And then they're both arrested in December.
Powell, bus stop. Powell, bus stop,
No, POW, White Castle,
White Castle.
bus stop.
Bus stop, Thanksgiving.
Thanksgiving.
Okay.
Yep.
And see, I think what has happened there, what has happened
So
is
Powell was not shot at the White Castle.
he got shot on Thanksgiving.
No,
No.
he was
No.
shot on, well, basically beginning of January of this year.
Not
Listen.
at the White Castle.
Right.
This is a theory Your Honor.
Okay.
That isn't in that, did you put it?
Yeah, I'm confused.
I don't want you to think that he had.
The alleged motive for the White Castle shooting is the previous shooting of Jihad Powell.
Let's do this, so I just follow along. Because
That is
I
a
think,
theory of the Commonwealth.
so Powell,
I'm gonna give away this incredible $4,000. Wait, no, not this one. This incredible $4,000.
gets killed.
Say
That is Mekhi's brother.
January, let's say roughly January of 2021.
Right.
Okay, and I'm letting everyone know I asked this because I don't get to see discovery.
I-
I have no idea what the
It's
evidence is, what's
confusing.
going on. I pull things out of bits and pieces of what has been filed and what everybody's theories are. So that's why I'm trying to follow along as much as possible so that I can get this, so that I can make sure that I'm on one accord.
Yes.
Okay,
And
so
this-
then White Castles happens,
White Castle happens in March. The alleged motive for that
was that,
is Rajon Baskin was responsible for Jihad Powell.
right.
But Mr. Cable's not alleged to have participated in the White Castle shooting.
And the White Castle
That's
shooting
Mr.
is the one that
Moore.
deals with the other juvenile.
That's Mr. Moore and another individual who's not in this indictment by the name of Matthew Welch.
Okay,
That's in March.
all right.
The bus stop is in September. Once again, their theory, having missed Mr. Baskin back in March, they try again in September while he's at the bus stop. Once again, Mr. Baskin was hit at the White Castle, but did not die. He survived his injuries. So the theory is, and this is their theory, September, they try Mr. Baskin again. Once again, Mr. Baskin is not killed. Tyree Smith, an innocent bystander, is the one that ends up being killed there.
Okay.
All of those relate to their theory, to the January shooting of Jihad Powell. Now we get to November, Cortez Duncan. Here's where the problem is. Mr. Duncan, the evidence in that case has nothing to do with Jihad Powell, White Castle, or the bus stop shooting. This is why we're asking for a separate trial.
When did he get shot?
Thanksgiving
Thank you.
in the chest.
And I understand you.
I'm just trying to get it down because somewhere along the line, and I get it with good lawyering, he gets shot. I know he gets shot, and I know that when he gets shot, somebody else dies.
Correct. That's Thanksgiving.
That's
That's
Mr.
Thanksgiving.
Duncan. Yes, that's
All
Mr.
right,
Duncan.
and you have a defense for that. We'll deal with that later. Okay, I understand that one. And he's there, upstairs,
That's what we're saying.
allegedly,
That's
with the
what we're
gun,
saying.
allegedly.
Yes.
So that puts both of them in the same place at the same time on Thanksgiving. Both of them allegedly in the same place at the same time with text messages at the bus stop in September. White Castle was its own thing, and all of this apparently has stemmed, allegedly, from your brother being shot and killed. But
That's,
that, none of that is before the court, but that's the theory.
Well,
that's
Alright.
partially the Commonwealth's theory.
I don't think their theory
And
is.
someone's been on a manhunt for Mr. Baskin.
Yes, but that
Okay.
doesn't have anything to do with things.
No, I'm not the fact finder.
No,
I'm
no,
just
I
trying
know.
to figure out what the theory is. So
Right.
the common thread is Mr. Baskin has been at all of these events except for the last one, which was Mr. Duncan gets killed.
Right.
Right, but
So Baskin was at White Castle's, the bus stop.
And the theory is that he was
And-
involved in the Powell thing.
Mr. Paul.
Okay.
But
But
so
that's
my-
why he's saying that the,
But that's my point, is when they list the evidence, and they list them in two separate paragraphs, they don't list anything as pertaining to not motive, they don't have to prove motive, but their theory is not that the motive had anything to do with Mr. Baskin. There's no evidence, again, I just don't see what would come in as the Cortez Duncan that would be admissible in any of the other trials, other than the fact that these guys know each other, and that they allegedly had done something together on a previous occasion, which is propensity evidence or bad character evidence, however you want to characterize it. But I haven't seen in their response where they're even alleging a similar motive between the, or any similar evidence, because they don't list it in the
But they've both been
response.
charged with
They don't
murder
list it in the
regarding the
response.
Thanksgiving incident, correct?
Right,
Okay, where Duncan was killed,
right,
right?
right.
And everybody was present, allegedly.
That's what we're saying, yes.
Okay. And they've both been charged with the incident that occurred at the bus stop where Tyree Smith was killed.
Right,
And allegedly they were both there.
right,
Text messages, etc.
right.
Moore has been charged with White Castle with Welch.
Yes.
Okay. So, I'm not having 6 trials. I'm not doing that. I'm not calling in 6 people to reiterate the same exact thing over and over again. So that's not going to happen. I promise you, I'm not having 6 trials.
So Judge, if I could just, here's how I would suggest going about making the decision, because I think the problem is that a lot of the severance arguments, severance from each other, especially the severance arguments that Mr. Cable is making, have to do with severance of counts. And I think they're being mixed and it's confusing. My suggestion is you make a decision, should these 2 defendants be tried together, period. And Mr. Ferracino, I don't know that he was exactly arguing this, but I agree that that is an easier decision, because in both the bus stop and the Thanksgiving, the Commonwealth's proof is that they did it together, that they were in the same Jeep in the bus stop. They shot out of the same Jeep. There is ballistic evidence that shows that there were 2 guns that were used in that incident. So that the bus stop should be tried with both of them together, because there is no reason under the law that there should be 2 separate trials when we are talking about the same
incident.
thing. Then my suggestion is that you make a determination, should they be tried together on the Thanksgiving day? And the answer is yes, because again, we are alleging that they went together to this location and that Cortez Duncan was shot, and in the process that Mr. Cable was shot. And although Moore and Cable denied knowing each other, Cable's blood is on Moore, clearly showing that at the time that Cable was shot, he was with Moore. And that we would have evidence to indicate that when that was happening, they were shooting Cortez Duncan. So there's no reason under the law to say that on the Thanksgiving that they should not be tried together. It's the same facts, it's gonna be the same witnesses. And in this case, unlike maybe some of the other cases you've had, there aren't statement issues. You know, sometimes joinder of defendants, 2 defendants being tried in the same incident can be done, but it is difficult because one defendant talks and they give information about the other defendant, and then you have a Crawford problem. Okay, well, we don't have that here. So we're not gonna have any of those type of issues. And even if we did, we could work through them, but we don't even have to. So my suggestion is that you make a determination. Does the bus stop case get tried with both of them?
Yeah.
The answer is yes. Does the Thanksgiving Day case get tried with both of them? The answer is yes. Then you decide, and I do agree that it is a harder question, do those 2 incidents get tried together?
Okay. So, now that I've got it straightened out, which is what I thought, I am going to sever the case that involves Mr. Welch, and have that to be tried separate from, although it lines up the same way, from the other charges. Okay? Bus stop, tried together. This is my preliminary. Okay? Bus stops absolutely tried together. With regard to the Thanksgiving incident, Ms. Parachia.
Judge, again, and I agree.
I get what you're saying, but it's judicial economy, and I'm not trying the same case 5,000 times. I'm not bringing victims back in here 1,000 times. When, in no offense, it's the same issue, it's the same facts, it's the same incident, right?
And I think that's what we're kind of.
Right, I have
We're not
no-
conceding that, but that if Thanksgiving, for the same logic as the bus stop.
Right.
That they would be tried together.
Right.
The
Well, that's
question-
what I'm differentiating, like, why not try them together for the Thanksgiving one as well?
That's an easier decision for the court to make. And if that's the court's decision, I can see why the court would want to do that.
Right.
Try them together for the Thanksgiving, but don't try Thanksgiving with bus stop.
Why not?
Because evidence from bus stop wouldn't be admissible at Thanksgiving, and evidence from Thanksgiving wouldn't be admissible at bus stop.
And I guess my argument to that would be that connecting them to each other
Right. It's
is
a common
connecting
thread.
them to the evidence for each incident. And that is why. It's because saying, I didn't have anything to do with that. Well, the fact that both of them had something to do with each one of those together, and that evidence is connected to them together, that connection of them to the evidence connects the evidence to the actual incident. And it's part of what the Commonwealth would argue. And I guess I understand your ruling as to the White Castle. I think what we would have to do on that is I'd have to give 404B notice, and then we talk about, even if they don't get tried together, does that information come in
Right.
as whatever? And we can do that another
And I
day.
just think with it being another person that's involved, with it being Mr. Walsh, et cetera, it's confusing enough for the court to cipher out. Especially when it has absolutely nothing to do with, Mr. Cable.
Well, and that's where I'm gonna argue to you on your 404 that it does, but I understand for
Okay.
severance purposes.
Okay.
I mean, I get it for counts, but like I said, that's another day.
Okay.
Yeah. So I think
Your
maybe.
Honor, I think that the bus stop and the Thanksgiving, the only thing they're having in common is that the co-defendants are both charged and they're co-defendants.
Mm-hmm.
I just don't think that that's strong enough under the law. I think the legal argument here is that for counts, the offenses are of the same similar character based on the same acts or transactions connected together or constituting parts of a common scheme or plan. And if the victims were the same, if this was like a string of robberies and so they all need to be tried together because they just didn't get caught until this point. Like if there was something that connected them other than the fact that they both were just charged, I think that's why they need to be separate trials.
And I hear your argument, but that's like a string of murders, right?
Well,
so, and I get it.
For like a serial killer.
But you can't
like
have a
if
string
there's
of
something
murders.
That you think that, like, here's something connecting all of
I get it, but you can only die once, so you're not going to have the same victim in a murder case. You'd have multiple. So I get what you're saying. I understand, right?
But then every shooting that would all just be all tried together.
If they were the same defendants, working in concert with each other, I mean, I think that's what you're saying is, it's not one person doing,
Right.
it's the connection to each other. The evidence that they are doing these things together is evidence connecting them separately.
Right.
That's
So
what
I
we're
get,
saying.
and I get what you're saying, but my,
At the trials regardless.
right,
But
so there's
the
DNA
admissible-
evidence that places him
Okay.
and that places both of them at the Thanksgiving shooting, which resulted in someone's death.
Yes.
So, but if they were, like Mr. Faraccio said, if these were separate trials,
Mm-hmm.
just because they were shootings, that doesn't make them, the same incident. These were months and months and months apart. And if,
So you want me to trifurcate it?
So-
Or bifurcate it and try the first murder and then have the jury come back and do the second one?
I think that the jury should never, I don't think that the jury should hear about the Thanksgiving Day issue where my client was shot with the same jury that hears about the bus stop. I just think that there should be 3 trials. I think the main purpose is specifically for this. If you did one shooting, you did another.
That's.
There's gotta be more.
I mean, I get that,
That, I
but
believe
just
that
because
is
you get
the-
shot at a shootout,
That is their argument in essence, is that if you did this, you must have done this.
No, it's that.
no, it's that
It's
they
the
were both
connection.
there at the same time in the
Yeah.
same, that's what I'm hearing. They were both there at the same time, at the same place, and someone pops up dead. And he just so happened to get shot too, which he has a defense to that.
Yeah, it's the connection.
That's what I'm
to
hearing.
each other. That
Obviously,
is what I'm saying, yes.
That you all know the facts of the case, you all have argued back and forth, so you all have intrinsic knowledge of things that have been said. But from my perspective, when I'm sitting here listening, the only thing that I've heard is they both were at the bus stop, someone popped up dead, they both were at Thanksgiving, someone ended up dead.
So, for example, if the bus stop shooting had happened, they were both then indicted on that, but they happen to be out of cut, or let's say they were both in the jail together and somebody pops up dead there, that new indictment would be a whole nother trial. That would not be merged into two trials together.
I didn't do the indictment to take them to grand jury. I mean, the fact that they're
Well,
all
I mean,
in
they
here
would
at the
be-
same time to be,
They would be separated had they not been later in time chronologically mushed all together.
But part of the way that this case was solved on the Thanksgiving Day shooting was because the bus stop incident had occurred involving these same two people. This is both by the homicide unit. They've got these two individuals that they have evidence and they're actively investigating on the bus stop shooting, and then the Thanksgiving Day happens, and the fact that they're connected together is part of what leads homicide detectives to say, okay, here's another one that these guys are doing together. And so I don't think that Ms. Fazio's analogy works. I mean, this was all part of it. They didn't get arrested until December, after the Thanksgiving, and it was all sort of solved as part of one collective investigation. And that's why they were indicted together.
And I don't think anything's been solved for Thanksgiving. I mean, in the Commonwealth's motion, it says we need to get to the truth of what happened that night. They don't know what happened that night.
I know that Cortez Duncan was killed by Mekhi Cable and Demaurion Moore, and I intend to prove it to a jury.
okay. All right. Anything else? Anybody want to draft anything? I'm gonna take it under submission. I'm trying them together for the bus stop. I'm not gonna sever them for the bus stop. I'll make a decision about the Thanksgiving.
And once you rule on that, then I'll file my appropriate
404B.
And
Okay.
then we can talk about that on a different date.
Okay.
And Judge, and I didn't file a response.
You want to file a
to
response?
No, I'm sorry, I filed my motion, Commonwealth responded, I responded to their response by saying, I'm not filing a written response, I'm just gonna say it for this afternoon, but there are other, so I stand by my motion that I filed, but there are other grounds in that
All
motion
right, let's do this.
as well,
Let's do
pertaining to jury selection and so on.
Let's
We
do
didn't
this.
address those today.
Let's do this. Because I'm spent. I'll give 10 days to defense counsel to supplement and respond to anything else. I'll give an additional 10 days to the Commonwealth, and I'll take it all under submission. Okay? So now I am orally saying, preliminary, my thought process is that I'm trying them together on the bus stop, that I'm severing the incident that occurred at the White Castles with Mr. Welch. Totally separate trial. And I have yet to make where I'm leading for the Thanksgiving. But none of those decisions are final. I'll allow you all to brief it. And if you persuade me to change my mind, you persuade me to change my mind. But I'll get an order out before we come back to the next pretrial conference. And then you can lay it out so that I can read it and see specifically what it is that you're saying, what it is that the facts actually are. That way, because listening to it is one thing, seeing it in writing and having it fleshed out is something different. Okay?
Thank you.
So I just want to make sure I understand. After your decision, you're going to give us 10 days to.
No, you brief it now. I'm giving you my thoughts.
Okay,
Have not made a final decision.
okay.
Wrap
10
it
days
up,
from
brief,
today.
right, 10 days from today.
Which is,
I don't know, 27. And then I'll give Miss Conroy 10 days to respond. Our next court date is
15.
the 15th. And that'll give me a couple of days to get the order out and filed and submitted to you all by the next court date. But you will have a response by the next court date.
Okay.
All right.
thank you, Judge.
Behave. I'm gonna check. I'm gonna call over and I'm gonna check. Behave.
And Your Honor,
And put a note that when they are transported, Penny, kids, they are absolutely not to be left in the same area together ever again.
Yes,
and
honestly,
Judge,
they
this
should be
was the
under
first,
government.
I had no idea.
I know you didn't know.
that any of this had
It's
happened.
fine. I wasn't blaming you all. That's why I addressed it on the record.
I've spoken with Demaurion about
Keep them apart.
Yeah, they should
Be
always
respectful.
be separate, but Your Honor, my understanding is that there was a third person that attacked both of them.
I don't care what happened. Don't fight. Period.
So check this out, squad. Evidently, them boys went on a crime spree. That's what I came up with. Says that Louisville is still trying to come up with terms with what happened after a 16-year-old Eastern High School student was shot and killed while waiting for his school bus. Tyree Smith was gunned down minutes after leaving his family home in Russell neighborhood in what police have said was a drive-by shooting. 2 other teens were injured, with one hospitalized in connection with the shooting. Roughly 24 hours later, schools were working to provide support to students. Community members are searching for answers on how to better protect kids, and law enforcement is searching for the clues to solve the case. Now, the mother also spoke out. Yeah, but back to the YSL. You know, it's a lot of emotions going on. I'm not finna go through all the emotions and do all that reading. You know, what I might do is post it for the squad. But I notice it's a lot of YouTubers that's going through reading emotions, and you know, I'm no lawyer. I done got sucked into this.
I never thought that me seeing my son over on the pavement, on the ground, crying, I never thought that'd be the last time I see my child alive.
Her home is now filled with grief. Sharita Smith and her husband Eric are still in shock that their 16-year-old son was shot and killed while waiting for his school bus.
He got a family, he got people that love him, and my son is gone because of nothing.
Smith got the phone call early Wednesday morning no mother should ever receive. It wasn't police telling her about the shooting. It was her 16-year-old son Tyree begging her to come to him.
He said, Mama, I'm shot, I'm dying. And I said, no, you're not. He said, hurry, Mama. And I said, I'm on my way.
She says the 3 blocks to get to her son seemed like an eternity. She got there and he saw her, but it was too late. He closed his eyes and never opened them again. She said the call he made to let her know he needed her will haunt her forever.
Just to hear the words, I'm dying, I just can't. I don't never want to hear it again come out of nobody's mouth.
Squad, could you imagine getting that call? Man, my heart go out to this young lady here. Send condolences to her family as well. But could you imagine getting that call from your child? You 3 blocks away, and the minute you get there, you see your child close their eyes.
Just can't think about what he was going through.
And the thought of living without her son is unbearable.
I never thought that I would be burying my child.
Sharita Smith says there were about 30 kids here at this bus stop at Dr. W.J. Hodge and Chestnut Street when shots rang out. She says her son died at a place he should have never had to worry about danger. Sharita says her son was a good kid. He went to school at Eastern High School and came home and had a job on the weekends. But someone's beef in the streets found him and took their son away.
I picked him up every night and brought him here. We know where he was at. Every morning I let them out this door. I know where they was going to.
So what give anybody else the right to take my kid away from me? It don't.
She wants answers, and whoever pulled the trigger, behind bars.
I'm angry. I'm angry because somebody knows something.
Natasha Williams, WLKY News.
You know what, squad? I don't have no answers, but I got some clues. You know, it's these loose laws they got. And just like Sonya Macy's father suggested, man, we probably need to get out there and vote in November. And if you know me, for me to be saying vote, this must be something serious. I've never voted a day in my life. This November, I think I'll be casting my vote, though, in honor of Sonya Macy. Man, again, I'm going to give condolences to this young lady and her family for her loss. Condolences to the Massey family. I am Mr. Follow-Up, so you know I will be 9 times out of 10 following up on this case, and we'll be back in the courtroom, especially since it seemed like this YSL trial. I think I think we at the end of that case there. You know, they talking mistrial. It's so many motions. We got motions coming from the defense. We got motions coming from the state. Recusals. Oh man, I ain't never knew this much about the law in my 52 years. But check this out. I am Mr. Follow-Up. Appreciate you rocking with me over here at Fly High Productions. Tune back in. You might want to subscribe and share the live with your favorite cousin. I'm out. Squad up.